Hello, everyone. Welcome to the Wills, Women, and Wealth podcast. I'm Elsa W. Smith, your Maryland estate planning and probate attorney, and I'm thrilled to have you with us today. We're here to empower women who value their health, wealth, and the legacies they're creating. This podcast delves into a diverse range of subjects encompassing finance, law, mental and physical health, and beyond. Our commitment is to furnish you with invaluable insights, engaging expert interviews, and enlightening episodes that address your questions on wills, estate planning, and probate matters. Remember, this is your community, and we want to hear from you. Engage with us, ask questions, suggest topics. Let's build a dialogue. Reach out to us on social media or leave us a comment below. Your input fuels the conversations we have. You can find all of our episodes on YouTube, Spotify, and Apple Podcasts. Be sure to subscribe and stay tuned for our upcoming content. We appreciate your support, and if you enjoy the podcast, please consider leaving us a 5-star review. Your review helps amplify our reach and brings our content to more listeners. And now, on with the podcast. In this special episode, I'm sharing the key takeaways from a powerful Maryland Public Television webinar, where I had the opportunity to speak about the essentials of estate planning. Presented in honor of National Estate Planning Awareness Week 2025, this session cuts through the confusion and breaks down what you truly need to protect your assets, your wishes, and the people you love. During the webinar, I walked attendees through the essential documents that form the foundation of a strong estate plan, practical steps to start or update their plan, and how proactive planning can support long-term financial security. I covered what I call the core 4 of estate planning: the last will and testament, power of attorney, advance directive, and HIPAA authorization. What each document does and why it matters, the role of a revocable living trust, how to properly fund a trust, and how wills and trust work together to create a complete, effective plan. This video gives you a quick overview of the most important insights from my webinar, Estate Planning Made Simple, so you can begin protecting your legacy with confidence. Enjoy. So welcome, everybody. Good evening, and thank you for joining us for Empowering Your Legacy, Estate Planning Made Simple. I'm Elsa W. Smith, managing member of the law offices of Elsa W. Smith, based in Annapolis, Maryland. Now, before we dive in, I want to take a moment to thank Maryland Public Television for inviting me to be a part of this important community initiative. MPT has a long history of serving Maryland families by providing trusted educational programming. And this webinar is another way that they're helping to empower our communities with practical information that can make a real difference. By the end of this webinar, you'll understand what estate planning really is, why it matters, and how to get started. I want you to feel informed and confident about taking your next step. Whether you're planning ahead, navigating a major life change, or simply curious, understanding estate planning is one of the greatest gifts you can give yourself and your family. Let's begin with the basics so everything that follows feels clear and grounded. So, what is estate planning, really? At its core, it's the process of making decisions today about how your assets, your health care, and your wishes will be handled, both while you're living and after you're gone. Now, many people assume estate planning is only for the wealthy or just for more older or seasoned adults. The truth is, it's for everyone, and that is all adults. Even if you don't own a home or have a large bank account, or you still have loved ones, responsibilities, and important decisions that deserve planning. Estate planning is about clarity, protection, and peace of mind. It ensures that your wishes are known, your loved ones are guided, and your family doesn't have to guess what you would have wanted, especially during difficult times. Before we explore the core four, it's important to start with one of the most familiar documents, the last will and testament. Understanding what it actually does and what it doesn't do is key to making informed decisions about your estate plan. So your will is the document that speaks for you after you're gone. It names who should inherit your property, everything from your home and savings to those special items that carry sentimental value. It also appoints your personal representative. In some states, this is known as an executor, the person responsible for ensuring your wishes are carried out. And if you have minor children, your will is also where you can name guardians to care for them. Now, why does it matter whether you have a will? Because if you pass away without a valid will in Maryland, not the state, not you, decides how your estate is distributed. That can lead to confusion, delays, and even disagreements among loved ones. Now, while having some or all of the core four documents is a great start, some people want to take their planning a step further. That's where living trust or revocable living trusts come in, offering added flexibility and control over your assets, both during your lifetime and afterward. A revocable living trust is a legal tool that allows you to own and manage your property while you are alive and control how it's distributed after your death. Unlike a will, which only takes effect after you pass away, a living trust can be used right now. You, as the grantor, can place the assets into the trust, I should say, continue managing them yourself, and make changes or even revoke the trust at any time, hence the term revocable. They offer several key benefits. Privacy is one. Assets in the trust avoid public probate. Cost savings. They can reduce or even eliminate probate fees. Continuity. Your instructions for managing assets take effect immediately if you become incapacitated. In short, a living trust provides control, flexibility, and peace of mind for your family's future. It's important to note, however, that a living trust does not replace the core four. You still need a will, power of attorney, HIPAA authorization, and advanced medical directive, in my opinion. The trust simply adds another layer of protection and convenience. Now that we've covered what a revocable living trust is, let's talk about the step that makes it work: funding the trust. Understanding how to properly transfer assets into your trust is essential for ensuring it actually protects what you've built. Now, let's talk about funding your trust. Funding this trust means making sure it actually controls the assets that you intend. Some assets, like your home or business interests, must be formally transferred into the trust, making the trust the legal owner. Other assets,
such as investment accounts, retirement accounts, life insurance, and bank accounts, can name the trust as a beneficiary. They do not need to be retitled. The trust receives them directly when you pass away. Vehicles work a little differently. In Maryland, the Department of Motor Vehicles allows you to name a transfer on death beneficiary to transfer the vehicle directly to a person. So your car really doesn't have to go into the trust, and it's generally not recommended. Using the correct method for each type of asset ensures that the trust functions exactly as you intend, giving your loved ones a smoother and more predictable process after your passing. Of course, every person's situation is unique, and working with your estate planning attorney, you can create a plan tailored to your specific needs and goals. Now, your trust and will work hand in hand. The trust manages the assets inside it, as I said, and your will covers anything outside or anything that was left out. Together, they form a complete, coordinated estate plan that ensures nothing slips through the cracks. Hypothetical. Imagine Sarah owns a house, a brokerage account, and a retirement account. She creates a living trust and transfers the house and names the brokerage and retirement accounts as trust beneficiaries. She also creates a will. The trust will manage and distribute the assets that she put into it according to her instructions. The house and the investment accounts go directly to her beneficiaries without going through probate. But what about anything not in the trust? Let's say that Sarah also has a small savings account she forgot to assign a beneficiary to. Her will acts as a backup, directing, for example, that this account go to her children. In addition, Sarah's will can name guardians for her minor children, something the trust can't do. So the trust, again, handles the assets it contains efficiently, while the will ensures that nothing is left out and protects her family in other ways. Together, they make a complete and coordinated plan. One important note: any asset, as I said, left out of the trust that does not have a beneficiary designation, like a bank account or investment account, for example, without a payable on death designation, must go through probate. Probate is the court supervised process of distributing assets, which may be time consuming, public, and often costly. That's another reason why it's important to fund your trust or ensure assets have proper beneficiary designations. This way, you can help your loved ones avoid unnecessary delays and ensure that your wishes are carried out smoothly.
Now that we've walked through each of the essential documents, let's bring it all together. In this next part, we'll introduce your estate planning toolkit, a complete set of tools designed to protect you, your loved ones, and your legacy. And if you're ready to take the next step, I'll share how to get started today.
All right, so here is a simple way to think about your estate planning toolkit. The core 4 documents form the foundation. Now, there may be others, but for purposes of this presentation, I'm just focusing on these core 4 documents. They form the foundation. And a living trust can provide extra control and continuity. Your next steps are easy. Review what you already have. Identify any gaps and work with an estate planning attorney to create a plan tailored to your family. This is how you empower your legacy. And one point I wanted to mention as you're reviewing your documents, if they're, say, older than maybe 4 or 5, years old, even 10 years old. We've had folks contact our office with wills that are 10, 15 years old. They definitely need to be updated because life changes. Your preferences change. And it's always a good idea to refresh those documents based on changes that happen in your life, as I've mentioned earlier in this presentation. But having those, outdated, it could be an outdated document based on what your life circumstances are right now, can bring a lot of heartache to you and your loved ones. I can't tell you how many times, for an example, and focusing on an outdated will. A person dies with a will that they created maybe 10, 15 years ago. The person, the deceased, married again and had children, but there were no provisions in the will or any kind of estate planning for, this new family. But the will said what it said, and it doesn't really reflect the situation the deceased had at the moment of his or her passing. So that just brings a lot of heartache, confusion, and could have easily been remedied by just updating those documents or that document to reflect the person's current situation.
I want to give a special thank you to Maryland Public Television for making this webinar possible and for inviting me to speak on such an important topic. It's truly an honor to help keep our community informed and empowered as they work to protect their legacy. To hear the full Estate Planning Made Simple webinar, click the YouTube link in the show notes. Thank you for joining me for this special episode of the Wills, Women, and Wealth podcast. Until next time, stay informed, stay empowered, and take control of your legacy.